Welcome to California Tax Litigation Update. I'm Philip Barron, Chair of the BHBA's Taxation Law Section, and I'm delighted to introduce our speaker and legend of the tax section, Marty Dakessian. Marty is founder of Dakessian Law, where he represents California taxpayers in complex tax matters. With over 25 years of experience, including roles at the State Board of Equalization and as an equity partner at Reed Smith LLP, he has led teams to significant administrative and judicial victories. A frequent speaker at California tax conferences, Marty is recognized for his deep expertise in state and local tax law. And now, Marty, take it from here.
Philip, thank you. I appreciate the introduction. Before we get into the slides and the specific cases, I want to just give you an overview of what I plan to discuss. So we're going to discuss California state tax cases, Franchise Tax Board, and Department of Tax and Fee Administration. We're going to talk about why these particular cases that I am presenting to you matter, not just kind of an update as to this is what happened, A, B, and C, but why they matter, why they're important. And then whenever possible along the way, I'll provide you with some tips to put yourself and your clients in the best possible position to succeed in what is a very, very difficult task, which is to go against the state of California in tax matters and tax disputes. So with that, let's go to the next slide, please. Franchise Tax Board, which encompasses both corporate franchise and income tax, as well as personal income tax. We'll talk a little bit about, we'll select some cases from both sides of that. If we can go to the next slide. Let's start with a very, very interesting case called American Catalog Mailers versus Franchise Tax Board. The underlying substance of this has to do with California's jurisdictional limits on income taxation. Under federal law, there is a statute called Public Law 86-272. It says that if your only contact with a state, such as California, is to solicit sales of tangible goods, then you are not subject to the income taxing jurisdiction of that state. But anything in excess of those activities removes that protection. There is an entity called the Multi-State Tax Commission, which is a non-governmental entity, but it is essentially a collection of tax administrators from the various states and the goal of the organization is to establish multi-state tax uniformity and to issue model guidance for its various member states as to how to apply income tax laws, and in this case, how to interpret this jurisdictional limitation in Public Law 86-272 in light of certain technological advances. We know that our economy has changed a lot. We've gone to this digital economy. And so for rules on jurisdiction and what the limits of that jurisdiction are, how are those rules interpreted in light of certain technological advances? So for instance, the Multi-State Tax Commission has said that placing cookies on customer computers, providing post-sale assistance through email or chat functions, or accepting applications for employment online, among other things, these are considered to exceed that basic activity of soliciting sales of tangible goods in the state. And if you engage in these activities, you've blown your protection under 86-272, and you are now subject to tax in California. This is the Multi-State Tax Commission's guidance. Now, of course, California is its own sovereign state and still needs to establish its own standards, which California did in this case. And the way that it did it is what the subject of the controversy is here. California adopted these federal standards in a technical advice memorandum and began enforcing these standards against taxpayers. The American Catalog Mailers Association, which represents a bunch of out-of-state retailers, online retailers, and catalog retailers, remote retailers, sued the Franchise Tax Board in San Francisco County Superior Court, saying that the technical advice memorandum, the TAM, was an unlawful underground regulation and thus unenforceable. Well, what does that mean? An underground regulation is, let me just back up a second. In California, we have something called the Administrative Procedure Act. The Administrative Procedures Act in California says that if any administrative agency is going to adopt a rule or standard of general application, it must go through a specific stakeholder process, a specific administrative process where it proposes these regulations, gives notice to interested parties and stakeholders, conducts hearings, and allows those parties to participate and have a say in what the regulation actually looks like. What state agencies cannot do is to simply enforce rules of general application without going through this process. And this is kind of a recurring theme that we're seeing here in California tax litigation, where state taxing agencies are, instead of seeking legislative changes and legislative guidance or going through a proper regulatory process, are simply issuing pronouncements and imposing those pronouncements via administrative fiat on taxpayers. So ACMA said, no, you can't do that. So it sued the Franchise Tax Board in Superior Court, saying that you need to go through a proper process. You didn't do that. And so you've basically promulgated an underground reg. This is a subversion of the democratic process. You don't get to make the law, the legislature does, so on and so forth. And the San Francisco County Superior Court agreed with the American Catalog Mailers Association and ruled against the Franchise Tax Board and said, walk through the elements of what an underground regulation is, and decided that what the FTB had done was in fact a rule of general application, and basically said that that action was invalid. The Franchise Tax Board did not appeal this, but it took the TAM off of its website, and you can no longer find it now. And it is essentially promised not to enforce it as a rule of general application. So, of course, why does this matter? I think I've given you some of the background, which it might be self-evident why this matters, but in case you are wondering, underground regulations exist all over the tax code in California, or I should say all over the administration of the tax law in California. And as I said before, it's very important to go through a proper process where stakeholders have a say, and to avoid situations where the taxing agency just gets to decide what the law is and apply it as a general rule. That is not allowed. These are policy decisions that belong in the hands of the legislature, and it's not the job of the agencies to simply decide this is what we think is best. No, you contact stakeholders, you shine light on the process, and after all that input and procedure has been followed, well, then and only then can you adopt these regulations. And then, of course, the regulations cannot exceed the scope of the underlying statute. So these are really important issues in California. The other thing to keep in mind here is that the American Catalog Mailers Association brought a declaratory relief action under the government code as an organization. And so anytime you do something like that, standing becomes an issue, because the Franchise Tax Board or the taxing agency will argue that you do not have a direct and beneficial interest in the litigation, and therefore you are unable to bring that. Only, for example, a member of the American Catalog Mailers Association is allowed to bring an action like that, and the FTB will argue that that person needs to go through an administrative process and apply for a refund and so on and so forth. So whenever you see cases like this, and those standing arguments were, by the way, rejected by the trial court in American Catalog Mailers, but the key takeaway is the agencies will always try and erect procedural barriers to bringing these sorts of actions. They tried it here, it didn't work, and so this was a good outcome for taxpayers. Next slide, please. So appeal of Southern Minnesota beet sugar is an interesting case in terms of examining how our new, relatively new tax dispute resolution system in California is supposed to work. This is an Office of Tax Appeals decision that essentially involves the apportionment factor. And the key question is, do you get to include deductible income in the apportionment factor? So if we can take a step back, if you're a business in California that's doing business in multiple states, you are subject to what is known under California law as apportionment of the income. So essentially what happens is you look at what the overall income pie is, what's the base of income that this company is generating in multiple states, and what is California's slice of that pie? And how do we measure California's slice of that pie? So if you think of the income as a base, apportionment is, if you think of the income as a base and you think of it as a pie, apportionment is designed to measure the slice of that pie that California gets relative to other states. And in California, the current apportionment regime says that you look to, but in measuring that slice, you look to the sales in California in the numerator of the fraction divided by sales everywhere. This simple ratio is what's used to determine California's slice of that pie. But what goes into that apportionment factor? What goes into how do we count sales? And the definition of sales includes, gross receipts. What are gross receipts? And what happens when you have gross receipts that don't actually generate income? Because the goal of the apportionment formula is to reflect the income producing activity in California. So here the taxpayer had out-of-state income that was deductible as income from a cooperative under Revenue Tax Code 24405, the cooperative deduction. And so all the income was subject to a corresponding deduction. The taxpayer argued correctly that under California law, that still goes in the denominator of the apportionment formula. And the bigger the denominator, the smaller the apportionment factor, and the better that is generally for taxpayers who are in a income position. If you're in a loss position, then the opposite is true. But if you're in an income position, then a larger denominator is better for you. And so the FTB, of course, took the opposite position and said, you know what, we understand that the statute says gross receipts, but really this isn't generating any income and this is problematic and we can't include it. And the Office of Tax Appeals did what it should do, which is enforce the statute, and essentially said, look, FTB, we understand that you feel this way, but the statute requires that we put this in. There's no limitation on income that is subject to a corresponding deduction, and it's not necessarily, this has sort of been, sort of longstanding California law. This is what the statute says. If you want to make a change, go to the legislature. And so the Franchise Tax Board essentially said that, OTA, you don't really understand principles of cooperative income taxation. You don't really understand the appellant's business activity. You're making a mistake here. We're requesting a rehearing. OTA rejected the rehearing. And so why does this case matter? It matters because this issue of including receipts that don't generate a profit applies in a lot of different situations, not just in the case of cooperative income. So case in point, after the OTA released this decision and made it precedential, another company, Microsoft Corporation, decided to test whether this same concept could be extended to deductible foreign dividends, whether dividends that are deductible at least to the extent of 75% should be included as gross receipts in the denominator of Microsoft's apportionment formula. The FTB, of course, objected for the same reasons, and the OTA, to its credit, was consistent and ruled in favor of the taxpayer once again, in line with its decision in the Sugar Beets case. Except this time, the universe of affected taxpayers was much greater. The universe of potential refund dollars was much greater. It was into the hundreds of millions of dollars, at least. And so this was a very sort of interesting test to see how a massively impactful case would be decided by a new new administrative tax dispute agency, the OTA, which has been viewed with some skepticism by taxpayers ever since its inception in 2017. So OTA issues this key decision in favor of taxpayers. And so what happened next is sort of a prime example of what's wrong right now with California's tax system and what the problems are that taxpayers are facing. So instead of just sort of moving on and just accepting the OTA's decision, the Franchise Tax Board decided to go to the legislature and not only change the law going forward, but to change the law retroactively. And so the legislature decided in a budget bill that it was going to overrule the Microsoft and Minnesota Sugar Beets decisions retroactively by declaring not only changing the law going forward, but declaring what the intent of the legislature was in 1966 when this apportionment regime was adopted in California, and what these definitions meant and what the legislature some 50 plus years ago intended. And that's 60 years ago, I guess, now intended. And that is a problem. That is a problem. Retroactive taxation is a major problem. People who are in this area recognize that all the time. Businesses want to know what the rules are and they can adjust accordingly. If the rules are X, then we can do Y. But if the rules are X and then the rules change 60 years later, then that's a real problem. So we can go to the next slide, please. So what happens? So this new law passes to legislatively overrule these two taxpayer-friendly decisions at the OTA. So two taxpayer organizations decide that they're going to sue the state and decide that they're going to sue the Franchise Tax Board on grounds that this is a violation of the constitutional rights of taxpayers and that the retroactive application of this legislation is in violation of the Due Process Clause of the United States and California constitutions. And so the taxpayer groups, we get back to this issue of standing that I mentioned, never got to the substantive issue in this case because the Franchise Tax Board challenged whether or not they had standing to bring these actions versus a taxpayer in a normal refund context who's directly affected and can bring a refund action. That's sort of the normal course of action in tax litigation. And the FTB in this case was successful. It wasn't successful in American catalog mailers in terms of challenging standing, but standing is often a factual question. And the court here found that as far as the National Taxpayers Union was concerned, that it did not prove, it was unable to satisfy its burden of proof that it had an affected member. And as far as Caltax was concerned, the court held that although Caltax was able to prove that it had an affected member, it was not able to prove that that affected member had exhausted its administrative remedies. So now the case is up to actually Caltax has decided it's not going to appeal. And the National Taxpayers Union has filed an appeal. But the appeal is not going to address the underlying merits. It's only going to address this issue of standing. And then if they're successful, it's going to go back down and address the underlying issue. So, the takeaway for me here is that, we have a policy argument here, right? Should you consider activity that does not generate a profit? You can make arguments on both sides. The arguments cuts both ways for taxpayers and sometimes and often for the Franchise Tax Board. But ultimately, it's a policy decision. And like all policy decisions, it is reserved for the legislature, which is totally fine. The OTA made the right decision here. It decided this based on existing law and longstanding precedent, but you can't go back and, if you're the legislature, and decide these issues retroactively. And there are, lots of cases that say that. There are California Supreme Court pronouncements that say that. So let's see how this unfolds at the Court of Appeal in the NTU case. Next slide, please. Appeal of Janus Capital Group. So this is another interesting dispute, again, over an FTB regulation. And what happened here is that the taxpayer, an investment management company, provided services to mutual funds, filed its returns using the single sales factor formula, and the method applied by a special apportionment regulation, 25137-14, which says that gross receipts from sales of services to mutual funds should be assigned to the location of the mutual fund's shareholders. Not to the mutual funds themselves, but to their shareholders. And so the taxpayer here filed claims for refund, trying to assign its receipts to the locations of the funds themselves, not to their customers, not to their shareholders. And that's because the standard apportionment formula states that the receipts should be sourced to where the purchaser is located. And the purchaser in this case would be the mutual funds. And the premise behind this whole regulation, the taxpayer argues, has expired. California went through a change in 2013 to move from an apportionment formula that measured California's slice of the pie, not just by sales, which is the law today, but also including property and payroll. And the underlying rationale for this regulation was directly connected to that property, payroll, and sales regime. It was adopted before the statutory change. And so while an argument could be made that this was appropriate back then, it's not appropriate now and is invalid and exceeds the scope of the FTB's authority. So This case is set for summary judgment. That's going to be heard in April of 2026, but another case challenging the FTB's regulatory authority. Very interesting. Next one, please. Smithfield versus FTB. Again, and sort of a common theme, we're having another dispute over apportionment, over measuring the slice of the pie. Here, the taxpayer was arguing that that essentially qualified for the agricultural business activities apportionment formula, which is a special one that uses the old property, payroll, and sales apportionment formula versus the new one that only uses sales. And so the taxpayer, which is the world's largest hog producer, argued that it satisfied the statutory definition of agricultural business activity, which means activities relating to any stock, dairy, poultry, fruit, et cetera, et cetera. It also includes activities relating to cultivating soil or harvesting any agricultural commodity, and felt that it was within the scope of the statute. The Franchise Tax Board adopted a regulation that, in the taxpayer's estimation, exceeded the scope of the statute because it linked to, well, not only linked to the business of farming as defined in the Treasury regulation, but the FTB took a very specific interpretation of what the business of farming means that, in the taxpayer's estimation, exceeded the scope of the statutory definition. So again, we have a case where taxpayers are testing the limits of the Franchise Tax Board's ability to interpret statutes, whether in an administrative pronouncement or through a duly adopted regulation. This is, sort of a hot button issue in California today. The trial in this case took place in December, and the parties are still awaiting decision. So one other thing that I was going to mention about this case, which is very interesting, is in speaking to counsel on both sides of this dispute. The FTB has argued that the taxpayers was, one of their arguments was a procedural one, which the FTB likes to do a lot to, avoid getting to the substantive issues. It likes to test the limits of the procedural requirements that taxpayers must follow. The FTB essentially said that the taxpayer failed to exhaust its administrative remedies because it failed to produce evidence at audit that is now producing at trial. And that's simply not true. The taxpayers in California tax litigation are entitled to a trial de novo in superior court. This means a brand new trial and brand new evidence is taken by a superior court judge. It's not restricted to the administrative record in any way, shape, or form, with limited exceptions, not relevant here. There are some cases where that might be true, but in a general refund action, it is 100% de novo. It's written in the statute. And so, we cannot, this is a brand new record. So you can essentially in California file a refund claim, not provide any supporting evidence, have it be denied or deemed denied, and then go immediately to superior court for a trial de novo. That is allowed under California procedure. So this position that I'm told that the FTB took in this case is totally invalid. With that being said, you do want to make sure to raise all arguments in the presentation of your refund claim or in the administrative prosecution of that claim to avoid any headaches later. Next slide, please. So now we're going to talk about a personal income tax case that was somewhat impactful. And the issue here is how income of non-residents from the sale of goodwill and other intangibles is treated for California. As we all know, California taxes the worldwide income of residents, regardless of source. But for non-residents, it can only tax income that has a source in California. So what happens when you have income from intangibles, say from the sale of stock? Well, under Revenue and Taxation Code, Section 17952, if you're a non-resident, California law follows what's known as the mobilia rule, which is rooted in the Constitution, really. And the rule is that income from the sale of intangibles, such as stock, is sourced to the taxpayer's domicile, to the non-resident's domicile, subject to two exceptions that are not relevant here, one of which is if you establish that if that intangible establishes situs in California, or if you are engaged in the regular trading of intangibles, then California gets to apportion some of that. But here in the JP Morgan trust case, the taxpayers were non-resident trusts and were shareholders of an S corporation. And the underlying business was sold, and the major portion of that sale was attributed to goodwill, which undisputedly is an intangible. So the Franchise Tax Board, and I'm editorializing here a little bit, but I think my comments are fair, adopted a regulation to specifically, I think, circumvent Section 17952 to state that where the income from intangibles is through the sale of an S corporation, then notwithstanding 17952, that's apportioned to California based on the factors of the underlying corporation, which to me is grossly in excess of the FTB's authority. In the Metropolis decision, the issue was not whether the regulation was invalid. The issue was whether the FTB's apportionment regulation ought to apply versus 17952, and based almost treating 17951-4, which is the regulation at issue, as an established co-equal rule along with the statute, which is actually what the court said, which is one of the many mistakes the court made in this case. And the court decided that because the regulation was more specific than the statute, that the regulation would apply, which was an incorrect result. And so the taxpayers ended up having to apportion their income and were not able to source the entirety of their income to the non-resident state, which I recall, if I recall correctly, was Delaware. So a couple of takeaways here, in my opinion. First of all, what we're seeing is over the years, the FTB and to some extent the courts have enabled the FTB to chip away at the favorable sourcing of income rules for non-residents. And so we are seeing this erosion in the mobilia rule. We're seeing this erosion of the rule that income from intangibles is sourced to domicile. And the FTB is via regulation carving out all these little exceptions to it, which in our view is not allowed. And so the issue of the regulations, another sort of important takeaway is that the issue of the regulations and whether the regulation was invalid was not raised in this case. And it wasn't raised because this was in a claim for refund posture. And at the OTA, the taxpayer did not raise the issue of the reg being invalid. And the likely reason for that is because prior to very recently, the Office of Tax Appeals' position was that it could not hear regulatory challenges. And that changed in very, very recently, relatively recently, less than a year ago, when the Attorney General opined that the Office of Tax Appeals does in fact have the ability to consider regulatory challenges in addition to deciding what I would call regular or substantive tax issues. And so that's likely the reason why it wasn't raised here. So the issue of the validity of the regs is still, in my opinion, an open question and could be challenged in the future. And if it's challenged, I think a court will see that this was a narrowing of Section 17952, a pretty unabashed narrowing of Section 17952, and the reg should probably be disallowed. So there you have it. I think we can move on to the next slide. Oh, I'm sorry. We have continuing slides here on the JP Morgan Trust case, which you can review later. We can go to the next slide. And we've got one more. Oh, okay. Well, I mean, I guess just as sort of a procedural point, the Court of Appeal in the JP Morgan Trust case said a couple of additional very interesting things. One, as I think I mentioned earlier, it said that regulations, and I think it was wrong in saying this, regulations, quasi-legislative regulations, have the dignity of statutes, which in some sense is true. But where the court went overboard and said that the regulation was co-equal to the statute and decided to apply the reg as the more specific statute. I mentioned that. The other thing that the court got wrong was that it decided that for the first time in 80 plus years, I've never even heard of this rule before, that the concept of business situs was not an all or nothing concept, that business situs was subject to partial situs and apportioned situs, which was a huge departure from existing law, not only in California, but throughout the country. And so despite all this, the California Supreme Court did not take the case. Review was denied. And we can now move on to the next slide. So California Department of Tax and Fee Administration, which covers sales and business tax cases. Next slide, please. Okay, so Olympus America, Inc. versus CDTFA. Interesting case here where the taxpayer incorporated repair parts into property used out of state under an optional maintenance contract. So property is going to be repaired. They send it into California. Taxpayer incorporates repair parts into that property. The taxpayer claimed an exclusion under Revenue Tax Code section 6009.1, arguing that because that property was going to be transported out of state and ultimately used out of state, that it came within the letter of the statute. The CDTFA instead argued that the statute was designed for property whose presence in the state is transitory and incidental to out-of-state use. It was not for equipment brought into the state to be repaired under contract. The taxpayer argued, in addition to the CDTFA's interpretation being incorrect, that the CDTFA's interpretation violated the Commerce Clause. The trial court did agree with the CDTFA's interpretation, and here argued that the constitutional arguments were waived because the taxpayer failed to address them. The taxpayer recently filed an appeal, so we'll see how that turns out. But a couple of the takeaways here. When you're litigating a tax case against the taxing agencies, you've got to go into it knowing that the trial courts are going to defer significantly to the interpretation of the taxing agencies. The taxing agencies will hammer on that, and trial courts, which are not specialized tax courts in California, they're general jurisdiction courts. They hear all kinds of different cases. Those are the same judges that are going to hear the tax case. So if they don't understand it, they will defer to the state. And that is sort of the default that you've got to come to grips with when you decide whether to move a case into litigation. So even in a case like this, where the CDTFA's interpretation might seem excessive, they seem to add words to the statute that don't exist. The trial court's going to give the agency a lot of leeway. And so you just have to know that. And, what's really important is being able to show mastery of the subject matter, make things easy for the trial court. Make a tax case not a tax case. I'm not saying, dumb it down, what I am saying, though, is don't make it unnecessarily complicated and be able to tell the court the story of what's actually happening here and be able to tap into a judge's instinct to do the right thing and to address evidentiary issues, to understand the facts of the case, and sometimes to make the case a narrow case, if you can, so that the court doesn't feel like it's going to do something, and if it decides to do something, it's going to be massively consequential. And so that could be another reason to sort of defer to the agencies and say, well, this is just this is too big of an issue. I'm going to let the Court of Appeal decide it. So this gives you an idea of, just sort of a deference that taxing agencies enjoy in front of the trial court. A couple of questions I would ask is, if the CDTFA is saying that the statute was designed for property whose presence in the state is transitory and incidental, it was not for equipment brought into the state to be repaired under contract, that seems like a general rule to me. Is this another underground regulation? It may have been worth it for the taxpayer to raise that issue and to, if nothing else, lower the degree of deference that the trial court would give to the CDTFA interpretation and say, you know what, you're saying this, CDTFA, but this is a general rule. It's not undergone the rigors of the administrative process. And so it's just your litigating position. And so to kind of decrease the respect and the deference that opinion might enjoy. And then the other thing that just sort of occurred to me is that Section 6009.1 of the Revenue Tax Code is not it's not an exemption, it's really an exclusion. And why would that matter? Why is that important? Well, exemptions are in their own separate section of the sales and use tax law. And this is in essentially the definitional provisions of the sales and use tax law. And the difference between an exclusion and exemption is exemptions are considered matters of legislative grace and are construed narrowly against the taxpayer, and all doubts are resolved in favor of the government. An exclusion, on the other hand, is part of the taxing scheme itself, like the imposition of the tax itself. And statutes imposing taxes, the opposite is true, that they're what the courts call ad invitem, and the doubts are resolved in favor of the taxpayer. So I'm wondering whether or not that's an argument that should be raised by the taxpayer at the Court of Appeal, or whether or not that was discussed. I didn't see it discussed from the documents that I had. Next slide, please. Medtronic versus CDTFA. Another interesting case. This one has to do with an exemption, the medical devices exemption. We just talked about exclusion versus exemption. This exemption is actually found in the exemption section. It is clearly an exemption and construed narrowly against the taxpayer. And again, that is something that whenever you're dealing with an exemption statute, that can cloud the discussion and really tip the scales even more in favor of the taxing agency. They already are enjoying some level of deference going into it. And then when you have a rule that says that exemptions are construed against the taxpayer and all doubts are resolved in favor of the government, it makes it really hard. So you have to show that you clearly come within the scope of the exemption. And here, Medtronic was trying to get a refund for its insertable cardiac monitors, saying that they were they fit within the definition of medicines under 6369 of the Revenue Tax Code, or they were an implantable device and they were exempt under that rule. And the CDTFA argued that the definition of medicines does not include devices at all. And so the statute itself just specifically excludes devices. And if you're trying to taxpayer get an exemption for an implantable device, well, the exemption doesn't include cardiac monitors because this only includes implantable devices that assist in the functioning of an organ. And these don't assist in the functioning of the organ. They only monitor the organ. And so they don't come clearly within the statutory exemption. In addition to its statutory arguments, the taxpayer, I think what they really were focusing on was the regulation. And there's a specific regulation that actually was, quite favorable to the taxpayer in this situation that says that the exemption includes articles permanently implanted in the human body to mark the location of a medical condition. And based on that description, permanently implanted in the human body to mark the location of a medical condition, I think you can argue persuasively that includes cardiac monitors. But here's what happened. Very interesting decision. The court said, we are bound by what the statute says, which is correct. But the regulation, even though it may have seemed to be in favor of the taxpayer, the court refused to consider it because it said that even if we were to consider the reg, essentially, we're not saying this, but the reg could exceed the scope of the statute. So we're not going to look at the reg. We're going to look at the four corners of the statute, and which is interesting because the regulation represents the CDTFA's interpretation of the statute, and the court was undeterred by that and said, we've got to stay within the statute. You're not allowed the exemption. The regulation may exceed it. So it's interesting. And, the reason that this regulation was even there to begin with, and again, probably some commentary here, is the regulation was adopted by the State Board of Equalization. And we had a change in tax agencies in 2017. In July 1, 2017, the Board of Equalization's duties to administer the sales and use tax law were transferred to the California Department of Tax and Fee Administration. And the Board of Equalization had 5 elected members that ran it. The CDTFA has a single director who's answerable to the governor. And so what we have seen as a taxpayer community is that the CDTFA has revisited several what I would consider pro-taxpayer Board of Equalization policies and reversed them. And so the fact that this case got to litigation instead of the CDTFA saying, yeah, that's our regulation, we're going to follow it here, signals to me a shift in how sales and use tax law is being administered in California. So interesting. Next slide, please. We have more there on Medtronic that you can read later. Next slide. City of San Bruno versus California Department of Tax and Fee Administration. Well, this is interesting. So under California law, we have the state component of the sales and use tax. And then we also have the local component of the sales and use tax. And what has been the subject of considerable dispute and litigation is which jurisdictions get what amount of the local sales and use tax revenue. And in California, the law allows for local jurisdictions to enter into agreements with retailers to route local tax revenues to that particular jurisdiction versus having the revenue sprinkled throughout the state. So for example, in this case, San Bruno and Walmart entered into an agreement for Walmart to establish facilities within the boundaries of the city of San Bruno. And then that would allow Walmart sales, the sales tax on Walmart sales, to be routed to the city of San Bruno. Absent that, presumably the revenues would have been sprinkled throughout the various states based on customer location. But by establishing these facilities within the city of San Bruno, the revenue was, that portion of the revenue of the sales tax revenue attributable to Walmart sales was routed to San Bruno. And why would Walmart do that? Well, because these agreements call for the city and the retailer to share in the tax savings. So if revenue is coming to the city of San Bruno, Walmart will get a piece of that back. That's not exactly how these agreements are structured, but in substance, that's what's happening. Now, the fact is that these agreements have been allowed for decades. And in fact, the last two governors, Governor Newsom and before him, Governor Jerry Brown, both have supported these agreements and referred to them as valuable economic development tools. You can imagine that this is a divisive issue. A lot of the cities that are on the receiving end of this new revenue support it. Those that are losing the revenue are against it. And so there has been considerable discussion in the halls of the legislature as to whether to restrict, to limit, to modify, or to eliminate these agreements altogether. And those efforts have failed. So why do we have a controversy here? In my opinion, the California Department of Tax and Fee Administration does not like these agreements and has been trying to administratively eliminate them instead of continuing to pursue legislative reform or have a say in the legislative process. They have tried to shut these agreements down. And so this particular litigation was spawned by a CDTFA disallowance, essentially, of this agreement between San Bruno and Walmart. And so what's interesting here is that rather than go through the entire administrative process, Walmart and the city of San Bruno got their adverse audit level decision from the CDTFA, had discussions with CDTFA about why this was incorrect, and after those discussions were not fruitful, decided to go straight to court to challenge the decision. They bypassed the CDTFA petitions process, and they bypassed the Office of Tax Appeals on grounds of futility, based on that it would be pointless to go through the process with the CDTFA and the OTA, that this was somehow a fait accompli, that there was no point in doing that we all know how the agencies are going to rule, so let's just skip that and go directly to the trial court. Which is interesting. The futility exception to exhaustion of administrative remedies is a real thing, but it's difficult to enforce. It's difficult to prevail on the futility exception. And in this case was no exception. The trial court essentially ruled that the case is not ripe and that San Bruno and Walmart have not exhausted their administrative remedies. And even if if the court were to agree that the CDTFA process is futile, the same cannot be said of the Office of Tax Appeals. And so the case is stuck. Again, we have a procedural issue that is preventing the substantive issue from being considered. And so this is ongoing, and the CDTFA has filed a motion to dismiss, which will be heard on June 16th of this year. And so, I guess, my practitioner tip here is that if you try something like this and you don't exhaust your administrative remedies, you're likely to be stuck in court for years arguing over that issue. And will often delay, as it has in this case, getting to the underlying merits. And in most cases, it'll be longer than if you had simply moved as quickly as possible through the administrative process. If this now goes to the Court of Appeal, this will be another 2-3 years before the case is resolved on this procedural issue. And even if they're successful, they will have lost those years, and now they will finally get their opportunity to discuss the merits of the case. So if at all possible, and there are ways to shortcut the process, but do your best to always exhaust your administrative remedies. It's the number one defense that is raised by the state in any litigation. All right, next slide, please. Next slide, please. Okay. Andal versus Mardiros. What happened here? The Andal in this case, who is the plaintiff, is retired State Board of Equalization member Dean Andal. And he sued the California Department of Tax and Fee Administration, which is why Nicholas Mardiros is mentioned in the lawsuit. He was the director of the CDTFA at the time. And board member Andal sued the CDTFA under a provision under the taxpayer waste doctrine. And the case is about what Andal believes is the CDTFA enforcing an invalid underground regulation pertaining to local tax reallocation, which we just discussed in the City of San Bruno case. So let's take a step back. What is a taxpayer waste action? What is the taxpayer waste doctrine? So under common law, for about the last 100 years, you as a taxpayer in California can bring an action challenging the waste of government funds, challenging unlawful government expenditures. Case law has held that the enforcement of an invalid ordinance or an invalid law is in itself taxpayer waste and allows ordinary citizens to challenge illegal and wasteful government action. The standing requirements are very broad. All you need to show is that as a plaintiff, you've either paid an income tax, a property tax, or a use tax within 12 months before the filing of the complaint. You don't have to have a direct interest in the outcome of the case. It would help if you did to avoid any sort of standing challenges, but you're not required to. The taxpayer waste doctrine is very broad and is designed to serve as a check to allow people to try to overturn unlawful government action on the wasteful government spending. So Andal decides to bring this lawsuit under the taxpayer waste doctrine. He also decides to challenge the invalidity of the regulation under Government Code Section 11350. He also brings a writ of mandate action. And as expected, the Department of Tax and Fee Administration has challenged Andal's ability to bring the action. Their argument is that taxpayer waste actions are not designed for cases like this, that Andal does not have a direct and beneficial interest in the outcome, and that interested parties are the only ones who can bring these actions, and they need to do it by bringing a refund action. And that's just not the case, but that's what the CDTFA is arguing. The case is pending in Sacramento County Superior Court. And so we'll wait and see what happens. But if these procedural challenges are overturned, then the court will turn its attention to whether or not the test that the CDTFA adopted the genuine physical human interaction test, whether that is in fact an invalid underground regulation. So before we get to that, though, we have to first decide whether or not the plaintiff is the correct plaintiff. So the hearing on that, as you can see on the slide, is scheduled for February 20th, 2026. Next slide, please. And that brings us to Southwest Airlines versus California Department of Tax and Fee Administration. That's the last case in our selection today. And what happened in this case was we had state level law that said that the sales tax on jet fuel was limited to being taxed on only 25% of the gross receipts at the local level. A later change in state statute lifted the limitation so that localities could tax 100% of the gross receipts on the sale of jet fuel. Based on this change in statute, certain localities automatically increased the tax on sales of jet fuel from 25% to 100%, and they did so without voter approval. The taxpayer in this case, Southwest Jet Fuel, sued the CDTFA for a refund of the local portion of the sales tax on jet fuel. And the reason Southwest sued the CDTFA is because the CDTFA, under the Bradley-Burns Uniform Local Sales and Use Tax Act, has contracted with localities to administer and collect the tax on their behalf. So as part of that uniform act, the appropriate defendant here would be the CDTFA versus going to each of the localities and suing them for the refund. But of course, the localities are real parties in interest, so they intervened and were allowed to intervene in the lawsuit. And so taxpayer sues the CDTFA for a refund of the local portion of the sales tax. And the taxpayer's theory was that while the state statute authorized the tax, the increase of the tax from 25% to 100%, it did not actually impose the tax. And then under California statutory law, local governments are required, who wish to implement the higher tax, are required to seek voter approval under Proposition 62, which is a ballot measure. They're required to seek local voter approval in order to impose that tax. And it's not disputed here that the 7 counties at issue, which were all located in jurisdictions where there was significant airports and significant sales of jet fuel, it was undisputed that none of these counties had even adopted it. Well, except with, I think there was one county that adopted an ordinance, but it wasn't subject to voter approval. The remaining counties didn't even adopt an ordinance. They just started collecting the tax on 100%. So the trial court agreed with Southwest and said that this was an overreach by the localities. They should have subjected it to voter approval, but the Court of Appeal reversed. And the Court of Appeal reversed and essentially said that this wasn't really a tax increase because it didn't really increase the base of tax, because the same group of people were still being taxed, and that this wasn't the disallowance of an exemption really wasn't an increase in tax, which is not the law. It's contrary to case law, but the Court of Appeal, of course, I'm editorializing here. The Court of Appeal did in fact reverse, and the California Supreme Court denied review in this case, and so that's kind of where this case ended up. And so we'll see if there's any more to come on the Southwest case. But again, what's interesting, voter approval. I thought that this case, especially with a trial court win and with the issue of voter approval at stake, I didn't think the Court of Appeal would disturb it, but they went ahead and they reversed, which was interesting. So in the last few minutes that we have here, I will say that, winning tax cases and presenting tax cases successfully against California taxing agencies, requires really 3 different things. You have to know, of course, the underlying law and the facts of your case. You have to understand the intricacies of tax procedure so that you can choose the proper causes of action, maneuver as appropriate through the administrative and judicial process, and be able to get the outcome that your clients want. And sometimes, your clients want to resolve an issue as quickly as possible, get the best result as quickly as possible. And then other times, if the state is being unreasonable in terms of offering settlements and so forth, or taking really aggressive positions, sometimes your clients want to be able to go the distance, and they want to be able to go and do that as efficiently as possible. And, so understanding the procedure is really key. The third thing I would say is you need to be really undeterred by the length and the difficulty of the process. You can see these cases take time. I mean, some of these cases, the tax periods go back a decade or more, and you have a very robust administrative process that is a precursor to the litigation. So you could be at the Franchise Tax Board at the CDTFA and the Office of Tax Appeals for 4, 5, 6, 7, 8 years. Some cases, depending on what remedies are pursued, can, be at the administrative level 10 years or longer. You have to understand how to maneuver with that. How do you shortcut that process? And, the concluding thought I will sort of leave you with, and, we can take questions if there are any, is always be mindful of three things when you are litigating tax cases. Because of the length of the process, be mindful of managing costs. Be mindful of managing costs. Be mindful of managing risk. And maintain optionality. Maintain as many procedural remedies as options as you can. A lot of times this is about being determined and knocking on as many doors as possible until you get the answer that you want. So with that, I will conclude. I will thank you for your time and attention. And if we have any questions, I'm happy to take those.
It looks like we currently don't have any questions, so this concludes today's presentation. Thank you so much, Marty, for an excellent examination of recent cases, and thank you so much to our audience for joining us today. Have a great day, everybody.
Thank you.